Mark T. Bloomberg, Honorable Thomas C. Cameron, and presiding the Honorable Michael F. Gadola. All persons having been to Syria, drawing near to detention, and that shall be heard. God save the United States, state of Michigan.
Good morning. Good morning. All right. On behalf of my colleagues, Judge Spoonstra and Cameron, welcome to the Michigan Court of Appeals. This is panel 2 in Detroit, first day of our case call. I'll let all the lawyers know that we've read your briefs. We've had reports from our staff on all the cases on the docket today and tomorrow. So we're familiar with the facts. You don't need to belabor the facts in your argument. Just cut as quickly as possible to the most decisive legal issues and let us know succinctly why you think you should prevail in your appeal today. In cases involving minor children or protected persons, please use initials only, not full names. We are recording these proceedings. They'll be uploaded to YouTube in the next 24 hours, within the next 24 hours. With that, I think we can move to the first item of the day, first case of the day. That is item number 1, docket number 375518, People of the State of Michigan versus Darrell Wayne Felton Jr.
It was the court, Drew Walbeck, on behalf of Mr. Felton. I am predominantly here just in case the court has any questions, but I do want to address what has happened with Wilson, which is a case that I mentioned on page 7 of the brief. At the time, it was just a leave grant order, and the court has now released it, albeit an unpublished one. And I want to talk about Wilson just because it's pretty similar to this case, but has important distinctions. And by the way, Wilson's docket number is 374098. I thought Wilson was going to be helpful to the court because in that case, the issue was restitution for a $20,000 bench that was ordered as part of funeral costs. As it turned out, there's one very important factual distinction, and that is that this bench apparently served as a headstone. So in this case, these pendants, as far as the record supports, was not part of the funeral, and it in any way did not, they didn't. Well, the prosecution asserted below that they adorned the casket, but have since learned that that was not the case. And so, these were just something that the family decided to purchase from the funeral home, but they were not part of the funeral or related services. And so that's just an important distinction from Wilson. And notably, the court in Wilson rejected the idea that if it permits restitution in this case for the bench, then a family could have annual memorial services in perpetuity and get restitution for that. And the court rejected that again because it wasn't part of a funeral or related service. And the same is true for the pendants here. In terms of the offense variables, I won't go into them. I think the briefing is more than adequate. I would just highlight that OB5 is only scored for homicides and requires both a serious injury and a serious injury that requires professional treatment. Just ordinary grief that you would expect a family to experience following a homicide is not sufficient.
Wasn't there an indication that the victim's sister had sought and received counseling to deal with her grief?
There is, and that satisfies the requiring professional treatment part, but there's no indication of what consequences she experienced as a result of her grief that were serious or important or dangerous consequences. And then the other component here is that the family also made reference to the fact that Mr. Underwood's father had died recently. And so how are we distinguishing between a psychological injury from Mr. Underwood's death versus a death so close in time to his father's death? I think it's hard to disentangle those two events. As for OB6, when I read the statute, I think the legislature had in mind, we look at what offense was convicted, we match it to the mens rea in the statute, and that's what we go with, unless there's a jury verdict and the judge knew something the jury did not. In this case, it was a plea. We know the mens rea that goes with the sentencing offense. The trial court should be scoring the 10 points that goes with that. So unless the court has any questions.
Would you agree that the pendants at issue are fairly characterized as memorial jewelry?
That's what I believe them to be. The trial court posited that they may have held ashes, but the prosecution hasn't presented any evidence of that. So yeah, I think I refer to them as commemorative jewelry. Yeah.
Okay, thank you.
Any other questions?
No.
Okay, very good. Anything
Then-
else, Mr. Walbeck?
No, Your Honor. For those reasons, I would ask that the court vacate Mr. Felton's sentence and remand for resentencing and correction of restitution.
Very good. Thank you so much. Appreciate your argument. And the case is submitted. That brings us to item 2, docket number 373953, People of the State of Michigan versus Brianna Talon Lipscomb. Mr. Walbeck, you're back.
Good morning again. May it please the court, Drew Welbeck on behalf of Ms. Lipscomb. This case has 2 issues. One involves the search of Ms. Lipscomb's apartment. And the sentence pertains, or the second pertains to her sentence. Again, I think the briefing is more than sufficient on this. I think that the first issue comes down to the fact that the landlord did not let animal control in because it was concerned he needed to make repairs. Page 7 of the motion hearing is as far as you need to go. Why did you call animal control? Because they asked to be let in. He was letting animal control in. The need to make repairs didn't come up until after they went in and discovered the conditions. And obviously we can't use the results of the search to support the need for the search. And then the other component of that ties into it is the agency aspect. And the only reason the landlord was giving consent was because the state asked for permission to enter to investigate the dog. In terms of the sentence, obviously Judge Godola has already reached a conclusion on that. I would just highlight that the experience of the judges is not an issue. The question is whether they properly apply proportionality law. And Milbourne tells us that unless we're talking about the most serious circumstances with, the most recidivist offender, we don't do the maximum sentence. And at the same time, we have a presumption against, a jail sentence here. I don't know how to look at the facts of this case and say this is the most serious, outrageous, animal neglect case ever. We're talking about one animal who suffered no injury, obviously in unfortunate circumstances, but he had no actual physical ailments as a result. I have to assume that there are animal neglect cases where that's not the case, where the animals do actually experience harm. And those are the cases that potentially deserve the maximum sentence. And also, we're not talking about someone who has significant criminal history. And then the other reason that the trial court rejected the idea of probation is that it didn't believe she could follow court orders. Obviously, the prosecution has identified facts that would perhaps support that conclusion. The problem is the trial court itself still concluded she was able to be on bond. Not only did she have
Has she completed her sentence?
this sentence,
Yeah,
No, she was granted an appellate bond.
okay, so she hasn't served her any jail time.
She does have some, I think it's maybe a couple of weeks.
Okay, she hasn't completed her jail sentence.
Correct.
Gotcha.
Because the court granted an appellate bond. If the court didn't believe she could comply with court orders, why would it grant an appellate bond? Why did it grant a pretrial bond that it never revoked?
Probably because it would be moot by the time I got here.
That's true, but plenty of trial courts still don't grant appellate bonds because they're more worried about the defendant appearing than the mootness of the issue. And even still, there was still a pretrial bond that was never revoked. So it's hard to understand the court's conclusion that she couldn't comply with court orders. And then she was also on probation in another case, which the court was aware of. So for those reasons, I would ask that the court vacate Ms. Lipscomb's conviction or remand for a resentencing.
Pretty good. Counsel?
Allison Whitty on behalf of the people of the state of Michigan and the county of Ionia. I would also rely primarily on my briefing, but in response to Mr. Walbeck's arguments, I would point out that the primary focus of his argument in regards to the initial entry into the apartment focuses on whether or not the landlord was acting as a government agent. And almost all of the case law on point in that area addresses circumstances where a private citizen is making entry to an apartment or to a residence on the government's behalf, and then sees something and then conveys information to the government. And that's not the circumstances of this case. This is a government actor making entry on consent of a private individual. So most of that case law, I would argue, is perhaps relevant from a philosophical standpoint, but doesn't directly address the circumstances of this case. I would instead point to the numerous case law that says that a landlord is largely unable to grant consent to enter an apartment unless specifically contracted otherwise, and point to People versus Davis as giving most of the criteria to analyze whether or not a landlord has that properly granted authority. I think my briefing covers this pretty clearly, but the essential timeline of events conveyed clearly to the landlord that there had been an animal in the apartment for up to 6 days. No one was taking care of the animal. The animal in question was a dog. It appeared active. Logically, at that point, if no one is taking the animal out, the dog is defecating in the apartment, and there is an ongoing and increasing amount of property damage the landlord needs to address. And I think within those circumstances, he's well within his rights to grant consent to enter. Beyond that, there's an absence of other available agencies to assist him in that entry. Animal control is the only agency in Ionia County, private or public, that will remove a trapped dog from any location. We don't have private animal rescues. We don't have individuals that are out here doing this on their own. It's just animal control. So if that entry has to be made, then the landlord has to rely on this government agency to make that entry. Defense also argues that his concern for the welfare of the dog somehow supersedes his property interest as being a governmental interest in the animal's welfare. I would argue that that is a very ordinary human interest in animal welfare that's shared by most people and does not supersede his property interest and his right to make entry in emergency circumstances to protect his property. Beyond that, from a sentencing standpoint, I would argue that on all 3 points, the court did articulate reasons as to why the sentence that was handed down is appropriate. I agree strongly with Justice Godola. I'm sorry, Judge Godola. I apologize. In your dissent, I think that you hit the nail on the head. Essentially, the court's experience with the defendant in this case was very lengthy. This case had a pendency of over a year, and during the course of that pendency, there were numerous motions. The defendant went through 4 separate attorneys with motions related to all of those, the third of whom requested that her right to counsel be forfeited entirely. The fourth of whom was retained following that motion, which was not ultimately ruled on because she was believed to be absconding at the time. So her her attorney at that time was allowed to withdraw. There were moments where she reported that she had left the state in violation of her bond order. During the pendency of this case, she committed and was convicted of $20,000 worth of damage to the same apartment where this offense took place in what appeared to be retaliation. So the court's history with this particular defendant was extremely lengthy and had a fairly good picture of this defendant at the time that sentence was handed down. I would argue that when the judge said that he did not believe this defendant could comply with court orders, he had the experience necessary to draw that conclusion. And that's reflected in the longer record of the case. He described the conditions that the dog was left in as being a lengthy amount of time and outrageous conditions. It's difficult to obtain conclusive data about this level of animal neglect because these cases are rarely appealed. There's not much case law on them. I can say that anecdotally, I personally have handled every animal abuse and neglect case in Ionia County for the last 6 years. And in the majority of these circumstances, we see strong financial reasons why the neglect is occurring or strong mental health reasons. Neither of those are present in this case. Ms. Lipscomb had the ability and the mental capacity to care for this animal and made active choices not to. I think that contributes towards the outrageousness. And then finally, defense argues that she maintained innocence and that was held against her. I would argue that she did not maintain innocence. She actually admitted outright to the majority of the facts that gave rise to her conviction. She simply disagreed that she should be held criminally responsible for them. And that would be in itself a lack of remorse for the offense, which the judge, I think, was correct in pointing out that her viewing of herself as a victim is an indicator that she was not prepared to take the steps to correct her behavior and be in probation. Beyond that, I would rely on my briefs and answer any questions if the bench has any.
Could you respond to what Mr. Walbeck pointed out in the testimony of the landlord? He said at page 7 of
Yes, Your Honor.
trial transcript.
He actually
He's
says,
asked, why'd you let him in? Well, they asked. So suggesting that it had nothing to do with concern about the potential damage to the apartment.
yes. So Mr. Walbeck actually specifically said you need not look any further than page 7 on this answer, which is an interesting way to phrase it because beyond page 7, the landlord does clarify that situation. On page 14 and 15 specifically, he was asked if he let the landlord into the apartment and then clarified that that was not what happened, that they had reached out asking contact, and then based on the circumstances, they agreed to send animal control in. So the testimony on that is a little bit unclear, but the transcripts as a greater whole, I think, provide clarity. Essentially, that the landlord had been notified by the downstairs neighbor that there was this door hanger on the door. The door hangers were admitted at trial. They did not request entry. They only requested contact on those door hangers. And in the course of the conversation he had with animal control, they basically were like, yes, there appears to be a trap dog. The dog is in the apartment. The dog is likely doing damage. We need to get the dog out. And I don't know, it's difficult to say from the transcripts who initiated the idea of removing the dog because that was a joint conversation by phone. But I think it's very clear that the landlord's motivation in doing so was to protect his property, which is what the law would require of him.
Any other questions? Okay, thank you.
Thank you, Your Honor.
Mr. Walbeck?
Very briefly, I'll start by addressing the agent of the government argument. The purpose of that is not meant as a secondary reason to exclude the testimony of the animal control officer. The purpose of that is that to prevent the prosecution from using Mr. Bliss as a backup to present the same evidence. Basically, he wasn't just a private individual that could come and present the exact same testimony. I think they would still struggle to support the conviction and because they needed the animal control officer for the sanitary, whether it was sanitary conditions or not. But that was the purpose of that argument. I also, every time throughout the arguments below, the prosecution references Ms. Lipscomb's relationship with her attorneys. I'm not really sure how that's relevant to her sentence. There are a variety of factors that affect whether a client gets along with their attorney or even multiple attorneys.
She went through 4 lawyers in a misdemeanor case.
Actually, I think it was 3 lawyers. The 4th was her appellate lawyer.
Yeah. Okay.
And
4 then.
but regardless, how is that relevant to her sentence? It's relevant to whether she should be appointed a new attorney, but it's not really relevant to the proportionality of her sentence. And then to the point of, what was the intent here? In addition to the landlord who did sort of contradict himself, there was also Mr. Bliss, who at trial, when asked, why were you, sent there? His response was, I was sent to let animal control in. And I'm off the top of my head, I can't remember. He may have waffled on that too. But I think it's important that both the landlord and his contractor, their initial response was both, I wanted to let animal control in. And I think that reflects their true motives here. So unless there are any other
Anything
questions.
else? Okay, Mr. Walbeck, I'm sure you were thrilled to see your panel draw today. Thank you for appearing. Appreciate your arguments, and the case is submitted. Okay, that brings us to item number 3, docket number 372662. People of the State of Michigan versus James Allen Morris.
Good morning, Your Honors. May it please the court, Ashley Siegel on behalf of defendant appellant, Mr. Morris.
I'm sorry.
Yeah, Mr. Morton. Yes, thank you, Judge Boonstra. We've granted a request for Mr. Morton to appear remotely for questions, I think, on this case. Is that correct?
Yes, Your Honor, I just saw the order come through
Okay,
this morning.
so I don't know if he'll be doing that. Don't see any indication of it as of yet. He's only here to answer questions anyway. So why don't you go, we called the case. Go ahead and proceed with your argument.
On
1 second. Did you have?
Yeah, chair of.
If I hear from her, go ahead.
Okay, just to let the court know too, on Mr. Morton's behalf, the order just came in like 30 minutes ago. So
Yeah,
he
that's
might
fine.
not have seen it.
Right.
Good morning, Your Honors. So on the issue of sentencing, the FLE made issue of the fact that I didn't state in my question presented ineffective assistance of counsel, but then I did kind of belabor that point in the analysis portion. The sentence needs to be based on sufficient, accurate data and needs to be reasonable and proportionate. And I would argue that the court allowing no allocution on his behalf, no mitigating factors, no sentencing memorandum, no argument whatsoever when the court had to make this decision on such a large range of guidelines from 11 to 37 years. That's the difference between getting to see the parole board, getting a chance at rehabilitation, getting a chance at release and not. That's basically a life or death for Mr. Morris. So it's unexcusable that there was no advocate for him at sentencing. And that just goes to the fact that the court couldn't have fashioned a reasonable and proportionate sentence without that advocate, without him having an advocate in that behalf. So I'll move on to the next issue. The lay opinion, again, Appelli says that Mr. Erickson's testimony was proper lay opinion testimony. Our argument is that it wasn't proper, and it wasn't just his lay opinion testimony based on his experience. He didn't say, well, I have seen a delayed disclosure before, and so, it didn't dissuade me from further investigation because I've seen it before. He really went to great pains to say, well, in these cases, it's because a child is sexualized at a young age. They don't even realize it's abnormal till they grow up. They don't have a safe person to tell. It's not safe for them. And the way he did it, he really purported himself to be an expert, like he knew this, not just that he's seen it before in his own experience. And it would lead the triers of fact to believe that he's advocating that this is what happened in this case to the complaining witness. And then finally, my last argument is on the testimony, the other act's testimony that was given at the trial. There's several reasons why the defense attorney should have objected to it. Again, make the argument, and he didn't. Again, another example of just failing to advocate for his client. We know that obviously inherently other acts evidence is prejudicial. The question is whether it's unfairly prejudicial. And the other question is whether there's certain, the Watkins factors through MRA 403 prove that it's unfairly prejudicial, and that prejudice isn't outweighed by its value, its evidentiary value. In this case, the other act's witness it didn't, so you look at the factor, the Watkins factor of it being in the same temporal proximity. It didn't happen at the same time. This other ex witness didn't live in the house at the same time that the complaining witness alleges that the actions took place, that the offenses took place. The need for other evidence. We had the complaining witness's testimony. What need could there be for more evidence about other types of assaults that happened at a completely different time? And finally, the most important one for me is lack of trustworthiness. This other ex evidence testimony witness, she hated Mr. Morris. That was put on the record to the point where the judge said, okay, I think we've got it. She hates him. And there was a little bit of confusion in my brief about the whole 10 years, was the other act's evidence excluded because it was more than 10 years old. And I think that the trial prosecutor and I both kind of mistakenly said, that it's more than 10 years old. So we have to look at these other factors to find indicia of trustworthiness. Well, the law is it within 10 years of the charged conduct? So it's not automatically excluded under that. But I think that when we look at the policy reasons for that rule, that if it's more than 10 years before the charged conduct, it has to have these other indicia of trustworthiness. That goes to whether it's unfairly prejudicial because of a lack of trustworthiness. This is a case where there was no contemporaneous police reports of the other ex witnesses' complaints. There were no other, rape kits or any of those other factors. This was a situation where this other ex witness was interviewed in the course of the investigation of the complaining witness, and to seize the opportunity to stick it to someone she hates. Could be seen that way. That's a lack of trustworthiness, in my opinion, that should have rendered it excluded. And that is why defense counsel's motion to exclude these would not have been futile. It would have been reasonable, and he was ineffective for not doing that.
Anything else?
No, Your Honors.
Any questions for counsel? All right, thank you.
All right, thank you.
Appreciate it. Thank you for your arguments today. Appreciate your appearance in your court, and the case is submitted. That brings us to item number 4, docket number 373.
This
Yeah.
is Tara. Apparently Brett Morton was granted oral argument this morning. I just got a message from Lansing.
He was not granted oral argument, and the case has been submitted. So thanks, Tara. We've moved on to the next item. Okay. Item 4, docket number 373-912, People of the State of Michigan versus Gaetano. I don't know if it's Pape or Pepe or Pepe or whatever it is. You can tell me.
Thank you very much. Good morning, Chief Judge, other esteemed judges, Christopher Whitman and Michael Middlestad on behalf of Mr. Gaetano Pepe. An accused's right to be represented by counsel is a fundamental component of our criminal justice system. Lawyers in criminal cases are necessities, not luxuries. Their presence is essential because they are the means through which the other rights of the person on trial are secured. Those are not my words. That's the United States Supreme Court in Chronic. The right to an attorney is the most important individual right for an individual accused of a crime, up there with the right to remain silent. The right to an attorney exists, but also does the right to self-represent. But unlike the right to an attorney, the right to self-represent is conditional. It requires more than invoking the right to an attorney during questioning, entering a guilty plea and waiving the right to remain silent, and waiving a jury trial, all important rights combined. That's why it's a structural error to deprive someone of their right to an attorney. The Michigan Supreme Court said there are stringent requirements, and the trial court must indulge every reasonable presumption against waiver, because we have to protect people from themselves from making what is oftentimes a bad decision in favor of a fair trial. There is no such script, but there's no such thing as close enough as well. Substantial compliance is required, and it requires discussing the substance of both the Anderson factors and MCR 6.005 directly with the accused, which occurs very seldom. In this case, the court did not have substantial compliance. It had subpar performance. Waiver was not valid. This was structural error, and a new trial is required. 97 words. That's just over double the length of the quote I started from Chronic. That's the total number of words that Mr. Pepe spoke between it being suggested that he waive the right to counsel and the end when this was granted by the trial court. Trial counsel, by comparison, spoke 224 words during that time in a conversation he did not even need to be involved with. The Michigan Supreme Court says there's supposed to be a searching inquiry during this process, and that did not occur. The suggestion did not come from Mr. Pepe, instead came from the prosecutor's office. The trial court approached Mr. Pepe with it, and Mr. Pepe's response is, I get to represent myself with counsel? As a question. That's not unequivocal, that's not informed, nor is it a request to represent himself. He had not thought about it, it appears, before this. The court says they have to go over a whole bunch of other things prior to allowing him to self-represent, but it did not live up to that promise. It talked about limitations it was going to place on Mr. Pepe that it would not place on trial counsel, but it did not discuss any pitfalls. The court then begins to look for the rules applicable to a self-representation, but admits the court is unprepared because it didn't know it was coming, but neither did Mr. Pepe. Mr. Pepe, as the plaintiff highlighted in their brief, repeatedly says yes. Yes, or a synonym of it, is 22 of his first 38 words, but still not unequivocal. And we know that because the trial court says, well, you're hesitating and you should. Despite that hesitation, as acknowledged by the court, there's no more discussion of disadvantages or pitfalls to Mr. Pepe. And the conversation that is had with what will be standby counsel is actually more detrimental because it makes it seem like standby counsel is actually going to be more active than standby counsel is. There's discussions of questioning the complainant will have to go through standby counsel because the trial court would not allow Mr. Pepe to question. So the final time Mr. Pepe is asked if he wants to represent himself, there have been no mention of the charges, mandatory penalties, the possible penalties, the actual dangers or disadvantages of representing himself, or that he can talk to an attorney about this. Mr. Pepe said yes, not knowing what he was agreeing to. Almost immediately, he's overwhelmed by just reviewing the jury instructions that the prosecutor proposed and ends up waiving a jury trial, which is also a very important right. Rather than go through all the factors and the issues, Mr. Middlestat was very thorough in his brief with regards to it. I'm going to focus primarily on responding to the plaintiff's arguments, which I qualify as 4 primary arguments. 1, the court should defer to the factual findings and under a clear error standard. 2, substantial compliance, which does not mean that there are stringent requirements. 3, failure to advise the maximum penalty is harmless error. And 4, the subsequent warnings were sufficient. So the legal standard, as this court is aware for the waiver of counsel, is de novo review. Credibility-based findings are reviewed for clear error. Mr. Pepe, whether it was knowing and voluntary, that's something subject to clear error. The law clearly requires the trial court make findings, and the trial court made no such findings here, so there's nothing to defer to. If the trial court had mentioned Anderson, had mentioned the court rule, and we cannot blame them for not saying these are my factual findings. But here there was absolutely no acknowledgement of those factors in either 6.005 or Anderson. So we can't infer that their factual findings were made depending on the decision when there's no acknowledgement of the decisions. As the court said, they're winging it. So this is a question of law subject to de novo review. In every case that both parties have cited, it involves the accused asking to represent themselves, and then the trial court doing a questioning of them to make sure that it's an informed decision and that that's what they want to do. That is not what happened here. It was suggested by the prosecutor. The trial court approached Mr. Pepe with it. He was asked to make an initial commitment within approximately 1 minute of that being proposed to him and a final decision within 20 minutes. That is not sufficient time. As the court is usually aware, what usually happens is someone in jail is talking to someone else. Jailhouse lawyers are telling them, yeah, represent yourself. Your attorney's a fool, things like that. They talk to family members. Maybe they do research. I believe the defendant in Adkins did his own research. They do this stuff and then they eventually get the courage to approach either the court or their attorney about representation. A good defense attorney should discourage an individual and say, you can talk about this. These are the problems. That's not what happened here. We have a proposal to a decision, final decision in 20 minutes. Moving on to the second issue, the prosecution says that there is substantial compliance here, relying on Adkins and Ball, which is an unpublished decision. This is a case-by-case determination, neither dictate a result here, but both of those cases are distinguishable. In Atkins, the idea to self-represent was Mr. Atkins. He did not hesitate, according to the court opinion. The court asked him his age, educational background, IQ, work history, if he could read and write the English language, discussed not just mentioning the court rules and the rules of evidence, but discussed how to make objections, disciplined if he spoke out, and then he'd have to act gentlemanly. He talked about you're going to be limited to what attorneys can do. Mentioned the acting Anderson factors and specifically made factual findings, none of which happened here. We know from the pre-sentence report in this case that Mr. Pepe had only graduated 8th grade. He had not got his GED. He had been unemployed for 10 years, and there's no record of his ability to read or write. And there's mention of that he could be deported as a result of this. A passing mention of the court rules without further context and how they're going to impose restrictions on him to admit evidence or keep evidence out was not made. No discussion of objections. With regards to Ball, it's largely devoid of any substance of factual information. We know 3 facts. He brought up representing himself, he was advised of the charges, and he talked to trial counsel who discouraged him, none of which happened here. One of the prosecution's arguments is that because the punishments had previously allegedly been made in front of Mr. Pepe, that should dictate the law here. We don't have to follow the stringent requirements. When the Michigan Supreme Court says stringent requirements and substantial compliance, that's what they mean. We have an Anderson test and 6.005, both that need to be satisfied for a reason. If, as the prosecution asserts, that arraignment is enough to inform someone of the maximum possible penalty and any mandatory penalties and the charges, the court rule wouldn't require it. It's similar to a plea in that way. When you enter a plea, the court has to tell you the charges, maximum possible penalty, any minimum penalty. It's required again, even if it happened at arraignment. Furthermore, there's no indication that any arraignment occurred here, which actually informed of the charges and the maximum minimum possible penalties. The district court arraignment was waived without the reading. The circuit court arraignment was waived without the reading. The only discussion pre-waiver was a discussion of a 25-year mandatory minimum at preliminary examination in the form of a plea deal. It's unclear from the record that Mr. Pepe was paying attention, was not talking with his counsel. This was not in the context of a discussion in discussion with Mr. Pepe where he rejected it and acknowledged it. And furthermore, it's not clear whether this is a killabrew to 25 years or if this is a mandatory minimum sentence. If this court says that the record is not clear, a waiver is not appropriate, and a new trial must be granted. There's a big difference between the court engaging in a direct dialogue with the court and just talking when somebody else is present. So here there was not substantial compliance. Briefly to touch on the third issue about whether this is harmless error. As this court is aware, this is a strict standard here. This is a structural error standard, so that would be weird if a harmless error applies. But when you read Campbell, it actually applies to subsequent warnings that do not have any constitutional underpinning, does not apply to 6.005D, the initial waiver colloquy. So that's inapplicable here. The substantial compliance with stringent requirements is that our courts being reasonable, both in the state of Michigan and the United States. This is the most important individual right, so it's obviously the most difficult to waive. And it's understandably difficult. The trial court here wanted to do the right thing, but they needed to consult with the court rule. They needed to take the break that was offered by defense counsel. They needed to consider the Anderson factors. It is reasonable for this court to ask trial courts to be prepared. It is reasonable for this court to not ask the trial courts to just wing it because they can get close enough. And it is reasonable for this court to ask trial courts to do it correctly eventually. Because while the trial court might have initially been unprepared, when it comes down to it, they had 3 more opportunities prior to trial to go say, oh, what was I supposed to do? And do it again. And just say, look, I want to do a more prepared, thorough examination here. There were 3 more opportunities and the trial court did not do so. So in conclusion, the waiver of the right to counsel has to be unequivocal, knowing, intelligent, informed, and a voluntary choice by the accused. It is not an option convenient to the prosecution to move a case to trial sooner or to have an unfair trial. It is not a convenient option for a court who's obviously frustrated and understandably frustrated with someone who wants to keep firing attorneys or wants to fire an attorney who might very well be a good attorney. And it's not a punishment for someone who wants to advance a defense that the trial counsel disagrees with. Michigan Supreme Court has said trial courts must indulge every reasonable presumption against waiver. If there's a question, the right to counsel must win and a new trial must be ordered. There's no such thing as a jump ball favoring the government in this situation. This was the prosecutor's idea. The trial court approached. Mr. Pepe was frustrated with his counsel. As the trial court highlighted, you've been in jail for over 2 years without so much as a trial. So the court knew that, but failed to mention the charges, possible penalties, mandatory penalties, any dangers, disadvantages, or pitfalls, or the opportunity to talk to appointed counsel. Mr. Pepe had 1 minute to make an initial decision, and a total of 20 minutes for the final decision was the entirety of the hearing. Mr. Pepe said yes repeatedly, but because the trial court did not fulfill his duties, then Mr. Pepe didn't know what he was saying yes to and became quickly overwhelmed with his waiving his right to a jury trial. This is a violation of Mr. Pepe's unconditional right to an attorney. It was a structural error requiring a new trial, and we ask that you grant that.
Any
Thank you.
questions? No, thank you. You have time for rebuttal.
Thank you.
Good morning, Danielle Kusan on behalf of the people from the County of Lapeer. The defendant has failed to show the error when the court accepted defendant's request to represent himself. For 817 days and more than 24 hearings, the defendant was represented by counsel prior to the decision to represent himself. There were 3 previous lawyers that were appointed that the defendant had gone through. During the motions to withdraw, discussions were had about the difficulties. There were difficulties with the defense strategy, defendant spouting out, I know the person who committed the crime and I'm innocent. That's why I'm trying to get through to these attorneys. I know the case better than anyone else. I think I'd be fine. And I can't go with attorneys because they're only looking at one side of the case. This defendant, like in Atkins, made a tactical decision to represent himself after the prior 3 court-appointed attorneys would not proceed in the way that he wanted.
Ms. Kusan, would you agree with me that this was perhaps not the waiver colloquy and subsequent times at which it was addressed with the defendant was not done in a textbook manner by the trial judge? So, the question becomes, was there substantial compliance? I think that's interesting to me. Mr. Wickman points out substantial compliance with stringent requirements. Stringent requirements, 2 terms that are clearly at odds with each other. I think we regard it as a substantial compliance kind of standard. So was there substantial compliance here?
The people argue there was substantial compliance, and I'd point out that in Atkins, there was the indication there is no litany approach. It's what the defendant understands at the time. And here the record reflect that there was an unequivocal affirmation 6 times on July 29th, 2024, that 3rd motion to withdraw when the defendant affirmed his desire to represent himself. The court did go over the dangers and pitfalls of him representing himself, talked about the experience on the other side, talked about the court rules and rules of evidence. And despite that, the defendant wanted to proceed. And in Ball case that we cited in our brief, it said even if there's a greater details possible, it doesn't make the waiver unknowing and unintelligent. The court did make a finding that the defendant knew what he was doing and accepted that. Defendant argues that there wasn't a description, a definition of the charges, maximum penalties, and the minimum. But again, in Atkins and in Ball, if the defendant's advised of the charges and possible penalties before the initial waiver, failure to do so at the initial waiver will not defeat the substantial compliance with MCR 6.005D. Again, we do believe there was substantial compliance, and point out the Michigan Supreme Court in Atkins said the act of insisting on the right to act as one's own attorney and then on appeal raising that issue makes a mockery of the criminal justice system and the constitutional rights to be protected. In this case, the court did substantially comply with Anderson and 6.005, and there were no violation of the defendant's constitutional rights.
Anything for council? All right, I don't think we have any questions for you.
Thank you.
Thank you. Mr. Lehman.
Thank you, Your Honor. And I will attempt to be brief. As the chief judge did note, this is not textbook, but it goes far beyond that. Atkins is clear that substantial compliance requires discussing the substance of both of those rules, the Anderson factors and MCR 6.005 directly with the defendant. And that's not what occurred in this case. The prosecution talked about this being a tactical decision. I think that if you look at the conversation that occurred, the few words spoken by Mr. Pepe, that he had not thought about it, then he didn't discuss it with anyone, that he didn't bring it up. It was an initial decision.
Doesn't he have a right to be informed that he can represent himself at some point? I mean, you make a big deal out of the fact that he didn't bring this up first, but I mean, you know, the court, I think, is understandably frustrated that every time we get to the trial date, oh, I need a new lawyer. Well, you know, you could represent yourself, which is his right. So, I mean, if no one had told him that up to now, someone probably should have, shouldn't they?
I don't think necessarily it's something that's regularly communicated. I did trial work for almost 15 years and I never brought up, even in my
I don't know
role.
what the harm is in
Sure.
telling him that he has that right. It is his right after all.
And I think if it was presented similarly to how it was in Atkins, is these are your options. You can continue with your current trial counsel. They could be standby counsel, or you could represent yourself. I think it's a very different thing. However, how it was presented in this case by the prosecution, I'll try to find the exact quote, was the prosecution indicating one of the options that this court has, and I'm actually going to reference the 72924 transcript at page 4, and the court has, and this is the prosecutor speaking, excuse me, had a number of options that it can do in order to continue this matter on trial counsel schedule. One being is if there's truly a breakdown, give Mr. Pepe the opportunity to represent himself with counsel at table. The court, in its then next statement, and just not saying that this is true or not, but if Mr. Pepe is the cause and Mr. Pepe feels that he's not being adequately represented, Mr. Pepe, you have a right to represent yourself. And so certainly that is an option that's available to you. And so I guess what I'm saying is your case is going to trial on August 27th. The court's not going to allow any further delay. You've been incarcerated longer than anyone in this court's memory since the judge has been on this court that hasn't gone to trial. It needs to go to trial. You've been in jail for over 800 days. And so this is your opportunity, Mr. Pepe. If you want an opportunity to represent yourself, you just need to tell the court now. If not, Mr. West, as unenviable a position as you might find yourself, you are Mr. Pepe's attorney. And so, Mr. Pepe, what are your thoughts? That is not the court presenting options. That is the court approaching with an option that was presented by the prosecution. And I think that it does matter the source of this idea, because there's a process for the accused in deciding to represent themselves.
How does he know he has the right if no one tells him? Why would you just assume that every person who appears in court as a defendant in a criminal matter knows that they possess that right?
Sure.
I'm no need to belabor it, but I'm puzzled by this, the significance you place on the fact that it didn't appear to be his idea originally.
Sure. And obviously the court's kind of throwing a hypothetical question, so I'm forced to speculate a little bit. He's been in jail for over 800 days. If no one's ever told him, screw your attorneys, you can represent yourself, excuse my language, I would be very shocked because that's not usually the experience that you have.
He seemed surprised when he was informed in the courtroom.
I agree, Your Honor, and I
He
think
said, really, I can do that or something to that effect. So with counsel.
yes, and I think that's
Yeah,
the
so.
that's
I
the
mean,
key determination, Your
so
Honor.
why does that matter?
I get to represent myself with counsel, question mark. It sounds like a tag team, Your Honor. So if Mr. Middlestat and I were both up here, making decisions, but I get to drive the bus and he's the passenger, is the opposite of the normal relationship. So that's Mr. Pepe's understanding of what he's being told. And I think it's important for it to be informed. And I think that, necessarily, I think that the suggestion is maybe not the best place that it's coming from. And this is not a rulemaking court to dictate decisions but I think that we should view any suggestion that comes from the prosecution or the judge, especially mid-hearing, as a little bit suspect. If you look at Adkins itself, the individual, Mr. Adkins, asked to represent himself. And the court did not immediately go into a colloquy, the detailed colloquy that we have eventually occurring. It says, we'll discuss that at your next hearing, because the court wants Mr. Adkins to have an opportunity to think about it, to do research, to talk to people, things like that. I think that could have happened here. As I said, there were three more subsequent hearings where the trial court could have engaged in an initial colloquy prior to trial. And if that had happened, we'd be arguing about whether that one motion hearing or that one pretrial was a critical stage. But instead, the trial court was unprepared, winged it, and just allowed it to go forward and never stopped to say, what should I have done? Let's go ahead and correct that. The only other thing I would say is that the prosecution suggesting it does matter, not only for the preparation time, because it does look potentially coercive or like ill-motived. No one self-represents because they're trying to help the prosecutor or help the trial court when they're being difficult. It's understandably frustrating, but what the trial court in this case should have done is say, Mr. West, there has not been a sufficient colloquy. If you want to talk to your client, you can engage in some kind of conversation. If this is still his decision, we can bring it up when we get to jury, the jury instructions pretrial that occurred next. And I think that very well could have happened. Mr. Pepe did, in fact, engage with Mr. West and was showing that he was willing to work with him when he communicated his decision to waive jury trial. So I think there's no reason that could not have occurred, especially given the source of the suggestion.
Counsel, do you agree that substantial compliance is the test, or is it your argument that substantial compliance is inconsistent with stringent requirements?
I do think that that's difficult, Your Honor, but I do think that they are consistent. And I was looking for the quote when the Chief Judge brought it up with regards from Russell, which is cited in our brief, has a good discussion about how this is a compromise, because this is the most important right, so it has to be stringent requirements. We have an Anderson and M 6.005 for a reason. So those are the requirements, but substantial compliance means there's no set script. I do aspire to be a judge someday. Sorry, Seda. They knew that. But when it comes down to it, I'm going to have a script. I'm going to have examples. I always say, and all of you have litigated, doing a trial is like riding a bike downhill while building it. That's something I think that communicates the difficulty. So I think that if you look at Russell, if you look at the discussion in Russell, it talks about substantial compliance softens it so that if you miss a word in the stringent requirement script, you're not automatically getting a new trial. That's unnecessarily harsh. But Adkins, Russell, all of it says that what substantial compliance means is that you do have to discuss the substance of these stringent requirements. So I think when it comes down to it, substantial compliance softens the language. It does not soften the requirements. Thank you.
Anything else?
Nothing for me.
All right. Case is submitted. Thank you for appearing here today. Appreciate your arguments.
Thank you, Your Honors. Have a good day.
Item 5, docket number 374524, People of the State of Michigan versus Claire Arthur Haskell.
Good morning, Your Honors. Mark Litton, appearing on behalf of the appellant defendant, Claire Haskell. So I'll be brief, Your Honors. Really, this comes down to one issue being that the trial court resolved factual disputes without permitting any factual development. I would begin with the fact that there was a failure to prepare an alibi notice in defense. And I can tell you, based on my interview with Mr. Haskell's wife, Kathleen Haskell, that she would have testified that she slept in the same bed as Claire Haskell every night, never woke with him missing or seeing anything that was concerning. But that witness was never interviewed. Witness wasn't called. That certainly could have impeached the credibility of the complainant in this case. We also have another issue with the fact that we have trial counsel never explored retaining an expert in the forensic interviewing field, despite the fact that we have the complainant's credibility being the main thing at issue in this trial. We also have the issue with the privileged medical records. Trial counsel never sought an in-camera review through a stand-away motion, despite the fact that there's evidence suggesting there was a potentially relevant impeachment material. In fact, there was evidence suggesting that the complainant had sex with another person and was concerned about being pregnant. Since I know that there's the issue with the DNA evidence that the prosecutor points to, but the case still remains primarily based on the credibility of the complainant in this matter. We have the issue that we have the complainant as the only eyewitness. We have supplemental witnesses who were introduced concerning disclosures. And then we have the forensic interview and the same testimony. However, a properly investigated forensic interview expert could have challenged the reliability of the disclosures. The privileged medical records could have produced impeachment evidence, and the additional investigation could have affected the jury's evaluation of the complainant's credibility in this case. The question is not whether DNA existed. The question is whether the jury's overall assessment of credibility may have changed. And the prosecutor essentially comes back with the argument that because there wasn't enough factual development, that the trial court's judgment or order was correct. However, absence of factual predicate actually demonstrates why at least a Ginter hearing was necessary for the defendant to be able to develop the record to bring up here before this panel. And at this point, we have really an inability to present these issues because we weren't even granted a Ginter hearing. So what I would be asking the panel is to at least remand the matter back to give Mr. Haskell a chance to develop his factual record through a Ginter hearing.
Any questions?
Questions?
Okay, that's not, we'll have time for rebuttal.
Morning, Danielle Kusan again from Lapeer County Prosecutor's Office on behalf of the people. The defendant here has failed to show there was an abuse of discretion in denying his motion for new trial based on ineffective assistance of counsel. Defendant claims the decision was outside the range of reasonable outcomes, but essentially ignores the DNA that was found, the defendant's DNA found in the victim's vaginal wall. As the court knows, in order to prevail for ineffective assistance claim, the appellant must show the performance fell below an objective standard of reasonableness, and there's a reasonable probability that in the absence of that error, the outcome would be different. Here, there's no reasonable possibility of an alibi defense. Kathleen Haskell did testify. She testified, and it was confirmed that she slept with a CPAP. There were times when her husband fell asleep in the chair. But also we heard the testimony of the complainant who indicated that when she was sexually assaulted, Kathleen Haskell was either asleep or at work. She was never in the same room. The complainant also indicated that the sexual assaults were too numerous to count. It is important to note that because this is criminal sexual conduct with a minor, time is not something that needs to be established. Therefore, having an alibi witness makes it a little more difficult. And the alibi defense, if any, would not overcome the corroborating DNA evidence. Appellant raises an issue with the competency evaluation and the request for an independent examination. It's kind of confusing because there was intermixing of criminal responsibility and competence. But either way, there's no good cause for an independent examination no way to show that it would have been reasonable for counsel to ask for an independent examination, therefore not a basis to show that trial counsel was ineffective. With respect to the forensic interviewing, this isn't a case where the victim didn't testify and we were relying on the information that was disclosed during the forensic interview. This was a victim who testified, preliminary examination, testified at trial, subject to cross-examination. As the court knows, the calling of an expert would be part of trial strategy. And again, the testimony of the victim is corroborated by the defendant's DNA in her vaginal wall. With respect to the privileged medical records, correct, counsel did not seek to access those records, but there's no showing that those records, a reasonable probability that those records are likely to contain favorable or material information. In fact, the insinuation is that the pregnancy scare was the defendant impregnated her, and that is what made her decide she should tell someone. Finally, with respect to the argument of cumulative error, like Allen, the defense has failed to establish there was any error, so there is no cumulative error. And like Knapp, the evidence of the defendant's guilt was substantial. The only explanation given by defense in the trial for why the defendant's DNA would have been in the victim's vaginal wall was the house was dusty and the DNA could have been contained in the dust. I think everyone would agree that is not a winning argument. We'd ask the court to affirm the conviction because the trial court did not abuse its discretion. Thank you.
Thank you. Mr. Linton, any rebuttal?
I would just say this, as far as the forensic interview, I mean, we have an issue in which there's much emphasis put on the fact that this was disclosed to Rachel Bennett, testified as to the disclosures. We have the issue of Detective Wells testifying regarding the forensic interview process, and we have DP, excuse me, regarding disclosures of Snapchat communications and statements allegedly identifying defendant. Now, the prosecutor emphasizes forensic interview during closing, that can be found on pages 854 to 857. And the issue that the trial counsel never consulted an expert regarding the interview protocols, the contamination, suggestibility, disclosure reliability, or interview techniques, I think clearly violates the Trachtenberg case, which the Michigan Supreme Court has held that the counsel has a constitutional duty to conduct a reasonable investigation and reasonable investigations before strategic decisions may receive deference. So trying to call this a matter of trial strategy, I think flies in the face of this particular holding. So again, I understand that the panel's handcuffed at this point due to the lack of factual development. So again, we would request that it be remanded for, again, their name. I don't know if there's any questions.
Any questions? No, we don't have any.
All right,
Thank you for appearing. Appreciate your arguments today and your appearance here in court. The case is submitted. That brings us to item 6, docket number 371944, People of the State of Michigan versus Demond Charles Williams.
Good morning.
Good morning.
Gautam Singh on behalf of Mr. Williams. And so I would briefly go over some arguments, although I'm going to primarily rely on my briefs.
Okay.
Or brief, I should say, for my arguments, and I would welcome any questions.
Okay.
So first of all, I just wanted to start by saying that in this particular case, Mr. Williams was convicted on a computer printout that no one had to defend. That is the real problem in this case. People argue that the printout was a business record. However, the printout was generated from data that was testimonial in nature. It was generated for data that was being captured to log compliance to a felony requirement. So the result, as a result, the data that was being entered was testimonial in nature. So Crawford, even though it says that business records, as an example, are non-testimonial, but it doesn't categorically say that all business records will be non-testimonial. It just uses that as dicta to say that business records, it basically says that all hearsay exceptions in general, excited utterances, present sense impressions, public records, in general, it kind of makes a case for those kinds of things to be non-testimonial. But the exceptions actually go to prove the rule there that, well, there are some things that are testimonial, even though they may be hearsay exceptions. So it doesn't say the primary holding of Crawford is that the defendant has a right to confront anyone who testifies against them. And in this case, there was an expectation that when the person, whoever was entering the records into the mixes database, knew that it could potentially reasonably be used for convicting someone of a felony.
I suppose that's true, Mr. Singh, that it could be, but would you agree with me that that's not the sole reason that these records are maintained, the child support records?
It is called, if you look at the full form for mixes, that's Michigan
Child support enforcement system.
Enforcement System. And the custodian is basically the felony child support personnel appointed by the forensic code. So it's reasonably expected that these records will be used by.
They can be, but that wasn't my question. There are other reasons that the records are maintained, one of which I think is the federal law requires it.
Of course, there are other reasons for accounting purposes.
Okay.
But
it's not solely to support law enforcement, in other words. Am I correct in that statement?
I would take that with a pinch of salt unless there was a case where someone was ordered by the court to pay child support. There would be no reason to
Civilly. I mean, that's a civil proceeding.
That's a civil proceeding.
Right. Okay.
I agree with you on that, but it's reasonably expected that they will be used.
I think that's a fair statement.
My second point, Your Honor, is, and thank you for the question. The second point, of course, is that with the Sixth Amendment, every defendant has a right to basically manage their own defense, and for a lawyer to unilaterally say that I'm going to not basically follow, every defendant has Sixth Amendment right to call a witness under the compulsory process.
Our right to confront the witnesses against him or her. His ex-wife was never testified in the criminal matter, did she?
She was not. So it was not so much of a confrontational clause issue. It was more of I have a right to have someone present a witness, and the lawyer does not unilaterally sort of negate that and says it's my trial strategy to not call this witness, particularly if this witness could be potentially favorable. And there's nothing on the record which says that this witness was investigated by the trial counsel and found to be unfavorable and therefore justified as a matter of trial practice to not call him. There's nothing on the record to state that. So that is our second point, that if under Bowie, if a defendant makes a request on the record, and which he did in this particular case, Mr. Williams said it pretty clearly that he wants Ms. Crooks to appear, and the trial counsel had to actually go on the record and say that I'm overriding Mr. Williams' request to have Ms. Crooks appear, and that's my tactical decision. And if Mr. Williams is unhappy with it, he's more than welcome to appeal it. So the categorical sort of silencing and I think blindfolding the jury is what the trial counsel actually eventually ended up doing, with where Mr. Williams wanted this witness to appear for whatever his, reasons might have been. That was his defense strategy, right? And the third thing obviously is the IAC claim, which is the basis of our two of our arguments in the, appellant's brief. The first one being total lack of investigation for the inability, I guess, what's the
Impossible.
impossibility, thank you, Your Honor, impossibility to meet the child support requirements. And total, I mean, we did the investigation in barely 2 weeks, and we found that there's, Mr. Williams did not have any liquid cash, no source of income, and he had a checkered history of selling assets and trying to make a living. He has no known place that he lives in, so we don't even know where he lives, and he owns one motorcycle, which is heavily encumbered. But the point there is that not the fact that he had some assets. The point is that there is a story to be told of his struggles. And the trial counsel totally ignored that story and never told any story even during the motion, the motion in limine that was brought up to rule out the impossibility defense from ever going into the jury, in front of the jury. He never brought out any of those factors, and all he relied on was totally showing up to the court and relying on Mr. Williams testifying. And that was total unpreparedness on his part. And the second point for our ineffective assistance of counsel claim was the fact that he unilaterally silenced the one potential favorable witness that Mr. Williams had, that is the custodial parent who Mr. Williams really wanted to have show up for the trial. And they were basically in an emergency motion like 3 days before the trial, were just pulled from the witness list, and there was no argument made by the trial counsel regarding the fact that Mr. Williams has a right to call a witness who might bear favorable testimony to his case. And so, and of course, that part, the IAC argument, is not fully developed on the record. I totally understand that. So we're asking for relief that, based on the plain error standard, which is fairly substantial standard, we're asking that this court essentially vacate the conviction and set this up for a new trial, because there was only one piece of evidence, and that was the printout. And the person who entered those entries, who made those entries into the log that was used to convict Mr. Williams, was never testifying, never had an opportunity to cross-examine that individual, or someone who personally knew why those entries were being made. These entries were presented as all-encompassing. They cover everything that was ever done to that particular case. So the first point is that we would like this court to consider reversing conviction and vacating that conviction and sending it back for a new trial. And in the alternative, if the panel does not feel that we've met the plain errors standard to a point where it needs to be met, then we want an alternative remand. We hold a Ginther hearing to develop our IAC claim a little bit further.
Any additional questions for Attorney Singh? All right. You will have time for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. Sarah Brenner, Assistant Attorney General for the People on this matter. Before I begin with my arguments, I do want to clarify that we saw a typo in our brief. So I wanted to be clear with the judges that there was an error on page 7 of our brief where we refer to our motion to amend was on the 27th. It was actually on the 22nd, which is before the trial date of the 26th. So I just wanted to be clear with that and make that correction. Counsel makes 2 challenges for the confrontation clause. And one of his main challenges is regarding the business record. The Michigan Child Support Enforcement System is basically like it's basically like a bank ledger that tracks monies coming in, monies going out, anything going through the system. It is not prepared for criminal proceedings. It's prepared for the civil proceedings and for the enforcement of that underlying civil order and just the tracking of those payments that both protect the payee and the payor so that everybody is shown to be in compliance with. It was not prepared for that. So it is not a testimonial document. It is an administrative record that was testified to by a friend of the court worker who was familiar with the system. It would be nearly impossible to have every single person that inputs a payment into that record come and testify. And I don't even believe that the system tracks who puts those payments in. It's a central registry mandated by the federal and the state government to be tracking those payment efforts. So it is not a testimonial. It is, and it was properly admitted and testified to. He had the opportunity to question the witness, the FOC witness, about that. So he did have the right to confront her regarding that record. Additionally, with the removal of the victim, the confrontation clause was not implicated because there was no out-of-court statements admitted or introduced by myself at the trial of that witness. I did not need any testimony from her to meet the elements of the crime. Now, regarding the ineffective assistance of counsel. Now, just because the trial attorney was ineffective does not mean that he was because he was unsuccessful does not mean that he was ineffective. In fact, his strategy was to leave little tidbits throughout the trial, leading the jury to believe that there could have been direct payments and that there was no testimony made. Now, he knew, and counsel says there was nothing in the record, but our police reports in these matters, there's always a question by our investigator when they're talking to these victims, and they ask them, have you ever been paid directly? And in this police report on this matter, the victim said, no, I've never received direct payments. So the attorney knew that to have her testify would thwart his whole strategy. So his strategy was to lay these little breadcrumbs, and he asked the front of the court worker, does this track any payments that are made outside of the system? No, it does not. So then at his closing argument, he tied that all together and he said, there's been no evidence here that shows that she wasn't paid directly because this system only tracks payments made through the system. So that was his entire strategy. And frankly, I was sweating a little bit when I went to the jury. And I think he, while not ineffective, was just unsuccessful in that matter. The jury did not pick up those little tidbits he was leaving. With regard to the impossibility standard. Now, the defendant refused to cooperate with his attorney in providing him with any medical documentation. And that's why when we did the impossibility hearing, his counsel and the judge made clear to the defendant, if you don't want to testify, if you don't want to provide anything, there's not really much that we can present. Even when appellate attorney went and researched, the defendant refused to cooperate with them. He refused to respond to their emails, to respond to their phone calls. But even if this defense attorney had gone and done all this research, he wouldn't be able to overcome the fact that the defendant did not file motions to modify his order when he knew that it had changed. And the evidence did show, and the documents that were admitted, the certified records that were admitted in this trial showed that he knew how to do that. So after the original order was entered, he did file a motion to modify, and it was granted, and his child support was reduced by almost half. And so going forward, he still failed to pay that reduced amount. And People versus Lakine specifically states that if they failed to exhaust all reasonable and lawful means of generating the income necessary to satisfy the support obligation, or failed to seek timely modification of the family court order when it became evident that it could not be performed, may singly or in combination defeat any claim that it was impossible for the defendant to comply with the order. So even if he had done this digging and trying to find out if he had any assets or anything that he could liquidate, he wouldn't meet that threshold. He didn't file a motion to modify. So right there, it wasn't impossible. So he doesn't meet the standards to prove that this counsel was ineffective. I would ask that you deny their request for a new trial. There would not be a different outcome. And I am happy to answer any questions or clarify.
For counsel. We
Thank
don't
you.
have any. Thank you. Mr. Singh, any rebuttal?
Very briefly, I think that just wanted to kind of come back to the ineffective assistance of counsel. There were other aspects of inadmissibility. Every defendant has a right not to testify, and I think that is something that is very fundamental to our Constitution. And for whatever Mr. Williams' reasons may have been, he may have chosen not to testify. But our little time that we had to investigate, there were no substantial assets, no liquid assets that he could use to pay, no source of income, no place to stay, a bankruptcy, debilitating medical injury, all of those things that could have been brought forth and were not. So we find that impossibility defense was basically waived by the trial counsel, and there was that was, I think, a big mistake. And of course, the second one being the constitutional right for a witness to call a favorable defendant, and it could be that Mr. The trial counsel chose that as a trial strategy, but we don't know. There's nothing in the record that I had that really showed that there was a conscious decision not to call Ms. Crooks. So I think for that reason, a remand would be appropriate to hold it into hearing to see what trial counsel has to say about those two aspects.
All right, very good. Thank you.
Thank you.
Appreciate your arguments. The case is submitted. That brings us to the last item on our 10 a.m. call. Item number 7, consolidated cases, docket numbers 372507 and 372510. People of the State of Michigan versus DeMontre Chris Hardman. Attorney Strauss will be appearing remotely for the appellant.
Okay. Good morning. Do you hear me, Your Honors?
We don't see you, but we don't see you, Mr. Strauss. Can you turn your camera on?
Yeah, I had the fancy, let me see. Oh, boy. Okay, here you go.
There you are.
I had the new setup, and all of a sudden my speaker kept going out, so I'm on the phone now.
Go ahead. You give us your appearance and
Gary Strauss on behalf of the defendant, Mr. Hardman, P48673. Really, I rely on the brief, Your Honor. I realized that the evidence is looked at in the light most favorable to the plaintiff, the prosecutor in this case, but that does not equate with disproving self-defense beyond a reasonable doubt. And both the Culbersons stated, and they didn't state that right away, but later in their testimony, that Mr. Hardman told the other man to leave him alone. And both of them said that, and I would just add that the video supports Mr. Hardman's testimony, and that he was worried. It was a very dangerous neighborhood. He was aware he had a gun. The decedent had a gun, and he did act in self-defense. And the other man was chasing him for a while, and they tried to portray him as a peacemaker, but then he was basically telling him to leave him alone. So I know there's not a lot of evidence, but that's the problem. The video supports his evidence, and the two witnesses that they largely rely upon said that he was telling the other man to leave him alone. So if there are any questions, I'm really here to answer questions because pretty much everything's in the brief.
Any questions for Mr. Strauss? No, we don't have any for you, but you will have an opportunity for rebuttal.
Thank you.
Counsel?
Good morning, Your Honors. Melissa Hoover appearing on behalf of the people from the Saginaw County Prosecutor's Office. I would also largely rely upon my brief as well. Just to briefly respond to Mr. Strauss's argument. I would obviously disagree. I don't believe the video supports any of Mr. Hardman's argument in this regard. The Culbersons, obviously, as I acknowledged in my brief, there were some inconsistencies in their testimonies, but also there were a number of consistencies, which I believe largely rebut the claim of self-defense in this case. Both testified that the victim, Isaiah Danks, was effectively trying to diffuse the situation here, that he looked scared, that he was backing off, and that the defendant was the one who was acting aggressively. And we also heard from the two witnesses, Simone Culberson and DeMarcus Fields, that the defendant at one point, and through the defendant's own testimony, he admitted that at one point he had not only his own firearm, but also the victim's firearm. And it was at that point that he claimed to have acted in self-defense, which again belies the claim that he acted out of necessity. So he defeated his own claim in that respect. So I don't believe that the video supports his claim of self-defense. It was actually more of a claim of what the video didn't show. That was the vast majority of his testimony. So for those reasons, Your Honors, as well as the reasons stated in my brief, I believe that the people effectively disproved the claim of self-defense and proved each and every element beyond a reasonable doubt, as shown by the jury's verdict in this case. And unless the court has any questions, I would rely upon my brief.
Any questions for counsel? No, thank you
Thank
very
you
much.
very much, Your Honor.
Appreciate your
Pleasure.
argument. You bet. Mr. Strauss, any rebuttal?
No, nothing to add, Your Honors.
Very good. Thank you.
Appreciate it.
Appreciate your arguments. The case is submitted.
Thank you.
Thank you. That brings us to the conclusion of our 10 a.m. call. We'll take a brief recess and come back for our 11 a.m. case call.
Travel Court of Appeals, State of Michigan is now.
All right. Take your seats. Okay. Welcome back. This is the 11 a.m. portion of our case call. Day one in Detroit, panel two. I'll just remind the lawyers, we've read your briefs. We've had reports on the cases, so you don't need to belabor the facts. Just tell us as succinctly as possible why you should prevail in your appeal today. In cases involving minor children, no proper names, just initials only. So with that, I will call the first case on our 11 a.m. docket. That is item number 8, consolidated cases, docket numbers 371359 and 371983. Power in the Praises Church versus Detroit Public Schools Community District. Attorney Shaw Hicks is appearing via Zoom, and there is an unusual aspect to this appeal. Consolidated cases, but the attorneys are endorsed for oral argument only in docket number 371983, which involves attorney fees. So I think we would be hearing from Ms. Shaw Hicks on that issue only to begin today's argument. So if she is present, we'll wait for her to appear.
Okay, can you see me now?
Yes, and we can hear you.
Great.
So give us your appearance. I don't know if you heard me, Attorney Shaw Hicks, but you and your opposing counsel are endorsed for argument only in docket number 983, 371983, which is the attorney fee portion of this appeal. And you are the appellant representing the appellant with respect to the attorney fees. So we'll take argument on the attorney fee issue, and you may proceed as the counsel for the appellant.
Thank you, Judge. Again, Rebecca Shaw Hicks on behalf of the Detroit Public Schools Community District. As many of the lawyers who have come before me today has indicated, I too will largely rely on my brief and my reply brief, but I did want to underscore just a couple of things to this panel. It's our position that the trial court did in fact abuse its discretion when it awarded the attorney fees and costs to appellee for appellant's alleged continual failure to go forward to close the sale of the property. First of all, there was no continual failure to close the sale of the property. In fact, there was a letter which is attached in my reply brief that Corporation Counsel sent to the plaintiff before this lawsuit was even filed, 2 weeks before the lawsuit was filed, as a matter of fact, that indicated we stand ready to sell the property. That was sent in April of 2022. Secondarily, the district renewed its offer to sell the subject property via an email exchange on October 31st, 2022, right after the trial court dismissed the tort claims. Another instance where we indicated our willingness to sell the property was at a motion hearing in which I appeared, which was in February 2024. So before and during the litigation, even, Detroit Public Schools Community District indicated our willingness to sell. After the litigation began, we were not willing to sell with the lost profits claim still hanging out there, but we were repeatedly willing to sell the property. And the next point I want to make is that here, there was no established court rule, statute, contractual provision, or common law exception that would apply to support the imposition of attorney's fees and costs. In terms of any common law exceptions, the American rule applies. There was no misconduct found by the judge during the course of the litigation that the plaintiff can point to that would entitle the Power and the Praises Church to attorney's fees. In the Persicini, I think I pronounced that correctly, case that the appellee cited, sanctions were imposed during the course of litigation for asking a highly prejudicial question during cross-examination. And in the Beagle case that plaintiff appellee cited, misconduct was found where a dispositive motion was filed 9 months post the deadline. We don't have any sort of misconduct during the course of litigation that would support the imposition of attorney's fees here. And lastly, I want to underscore that plaintiff cited MCL 600.2591 for the proposition that there was a frivolous defense and therefore attorney's fees were appropriate. There was no finding by the trial court judge, of any frivolous behavior or conduct in terms of our defense or our strategy during the course of litigation. So that statutory provision is inapplicable. It absolutely requires a finding of frivolousness before a judge can assess costs and fees. So for these reasons, we're asking that this panel reverse the decision of the trial court as it relates to the imposition of attorney's fees against my client.
Any questions for counsel? No. Okay, thank you.
Thank you.
We'll hear from your opposing counsel.
Good morning, Your Honors. Good morning, Ms. Hicks. May it please the court, Dewey Rick Martin appear on behalf of the church in this matter, which is the appellee in this particular docket. Throughout this over 2-year litigation, defendant consistently opposed specific performance in motions and in responses to plaintiff's requests for specific performance. In addition to filing numerous motions and responses, while at the same time holding the church's $139 paid as a deposit and never once agreeing to specific performance until 11 days before trial.
Mr. Martin, if I could interrupt you, I think what you said just now is factually true. But if I look at the record and the reason that the trial judge gave for imposing the award of attorney fees, she said, in this matter, defendant stipulates to its breach of the contract and as such specific performance is the proper remedy to give each party the benefit of the bargain without being inequitable. The court, however, finds that plaintiff is entitled to attorney fees and costs for having to prosecute this case due to defendant's continued refusal to go forward to close the sale of the property, which suggests to me it's somewhat ambiguous, but the judge awarded attorney fees on the basis that the lawsuit had to be filed in the first place. She doesn't cite any frivolousness in the arguments raised, the many motions that you point out that were brought before the court. She doesn't indicate that those were frivolous or didn't have any sort of reasonable basis in fact or law. It appears it was almost like a damage award, because, you had to bring this lawsuit, so I'm going to award you attorney fees, which I don't think is proper under the law. So can you address that?
Yes,
for
Your
us?
Honor. In a recent case, January 25, 2024, the case of Cedric Richardson versus Bridget Wright, the trial court stated, and it was upheld by this court, the trial court stated, if this case isn't frivolous, there's no case that would meet the standard for frivolous. This is clear. Paragraph 40, a deal is a deal. We have been litigating this case for however many months over something that a 12-year-old could read and understand about an appraisal and the $5,000 provision. It's frivolous. You're entitled to sanctions and costs. In this case, Your Honor, the fact that the defendant stipulated that it had breached the contract 11 days before facing a jury trial necessarily required the trial court to utilize its inherent authority to resolve the case and the issues. The court recognized that said stipulation, I think this is key, could have avoided 2 years of litigation if done at the point the case was filed. That inherent authority that defendant requested that the court use to resolve the case also provided the court with the power to impose attorney fees for 2 years of unnecessary litigation that the court was required to do in managing its docket. Defendant's request for the court to use its inherent authority to resolve the case by protecting it from a jury verdict eliminated the application of the American rule defense. Therefore, there was no abuse of discretion by the trial court in its use of its inherent authority to resolve the case in the manner in which it did. I cited the case of Wright, and in that case, it also said on page 12, given the plain language of the purchase agreement, Wright and her counsel had no reason to believe that the facts underlying this defense, the facts underlying were true. Accordingly, Wright's illusory promise defense, which was based on facts that she knew or had reason to know did not exist,
at the time that she asserted the defense was also frivolous. Now, Your Honor, the misconduct in this case, and the court cited on page 9, well, I won't go through that right now, but the misconduct, Your Honor, is defendants using a motion in limine for the improper purpose of avoiding a jury trial 11 days before the trial. I don't know what motion in limine says you could use it to say, hey, we'll do specific performance now. That is not the proper role of a motion in limine. And that is precisely what they did in this case. So here's a trial judge sitting for 2 years.
But just so I'm clear, the sanctions that were imposed was not for your costs associated with responding to that motion to eliminate, correct? It was broader than that. Am I correct?
That's correct.
Okay.
The court felt as though that motion in limine, that request of the court for specific performance could have and should have been filed when the lawsuit was filed. That's what the court is saying. As a result of that delay, 2 years, we have 179 pleadings, thousands of pages of documents the trial judge had to review in this case. If you look at the register of action, this is a case where 11 days before trial, oh, wait a minute, we don't want to face this jury verdict because now you're looking at damages. And the damage in this case would have exceeded $850,000. It was evaluated at $920,000. It didn't work to delay this case for 2 years. The church of a 50-member congregation endured. It was able to survive. So it didn't work. The plan was that the church would not be able to afford the cost of litigation for 2 years. And when the church was unable to endure, we get our property back, a property that's worth $1 million that we had previously agreed to sell for $100,000. The board ordered the board ordered the sale on December 8, 2020. The board specifically said, and this is Exhibit 1, per the approved lease agreement, the church was given the option to purchase the property prior to October 31, 2019. The church made an offer to purchase the property for $100,000 and has been negotiating a purchase price. The church has also agreed to pay all remaining delinquent rents in the amount of $10,677 from the first lease for a total closing payment of $110,677. The June 20 appraisal returned an $850,000 value. The tenant agreed to an anti-flip term of 7 years. During that period, the district will receive 50% of any resale price exceeding $200,000. And it ended with the district will receive $110,677 for the property and will have no financial liability or operation or burden on the building. It also referred to the purchase agreement. That was December 8th. On November the 5th, 2021, the court found that the defendant failed to appear at 2 closing. That is a breach of contract, clearly a breach of contract. And the closings were set by defendant's own agent. And defendant's own agent, Robert Johnson, the judge cited this. This is what Robert Johnson said. Robert Johnson, president of the state title company. He was hired to work and close the sale. Johnson also testified that he attempted to close the sale without success. He stated, well, we couldn't get Detroit to sign a closing package, and they kept saying this thing, and every time they request something, we changed it, even though we're not insuring them. Detroit wanted us to do. All right, and we're sitting with the closing package. Nobody is willing to help us at Detroit. The court also noted this. Johnson also testified he was unable to get anyone from DPSCD to sign the purchase agreement and title package. He said that he also sent a request, quote, 100 times for a document saying that the superintendent could sign the agreement. The judge noted, on the other hand, Bishop Henderson complied with his request for the $3,000 to the title work. The church also scrounged up $90,000 that was returned to them at the second closing. Robert Johnson says they're not, I don't know why they're not closing, but here's your money back. That's when litigation began, Your Honor. So what we're saying—
Mr. Martin, you're obviously very passionate about your argument. We understand that. I don't think any of us are overly impressed with the way the defendant conducted itself as a factual matter with respect to this whole transaction. But we're here on a pretty simple issue involving attorney fees. So I'm just going to ask you to summarize your argument for us so we can move on.
Your Honor, the trial court has the authority to order attorney fees. The inherent authority doesn't take a court rule. The inherent authority, where there is misconduct by a party or the counsel. The court obviously found the misconduct in that they waited 2.5 years, 11 days before trial, 11 days before Mr. Johnson is going to testify that, yeah, they breached, my client breached. They wait 11 days before trial to say, yes, we'll do specific performance.
Understood.
That is misconduct that I believe the court found, Your Honor. And I think that the court, I think that the defendant has failed to show an abuse of discretion.
Any other questions for Mr. Martin? Okay.
Thank
you
you
very much.
Thank you, Your
Appreciate
Honor.
your argument. Ms. Shaw Hicks, you have time for rebuttal.
Thank you, judges. We're relying on our brief and our reply brief. Thank you.
Thank you very much. Appreciate your arguments and for your appearance here today. The cases are submitted. All right, that brings us to item number 9, docket number 375689. Lawrence John Close II versus Angela Marie Close or Kloss. I'm not sure exactly how to pronounce that. Attorney Schmidt will be appearing remotely to answer questions only, representing the appellant in this matter. And there she is.
Good morning, Your Honors.
Good morning. Can we have your appearance? And then I'll ask my colleagues whether they have any questions for you.
Very good. Lisa Schmidt appearing on behalf of Angela Close. And I think, as Your Honor indicated or implied, my request for oral argument was denied yesterday afternoon. So I'm just here for questions.
Okay. Any questions for Attorney Schmidt? All right. We don't have any at this time. So I'll let your opposing counsel present her argument, and we will take it from there.
Very good.
Good morning, Your Honors. Trish Haas appearing on behalf of the appellee, Larry Close. Obviously, since I don't have appellant argument, I'm going to try to be brief here this morning.
Sure.
However, I'd just like to point out that the trial court did not abuse its discretion when it denied the appellant's request for attorney fees. This record is a little confusing, so I want to specify one important thing that the court must note. This is on remand, or actually in December of 2024, this court peremptorily reversed a parenting time order. Now, it peremptorily reversed a parenting time order that was entered on March 1st, 2014, and then reconsideration denied on March 14th, 2024. The important thing to note is the March 14th, 2024 order, which denied reconsideration, also expressly denied the request for attorney fees. Now, when the application for leave to appeal was filed in June of 2024, it only addressed the issue of parenting time. There was no application for the issue of attorney fees. And also, of course, from 21 days from March 14th, 2024, appellant had the right to file an appeal of right with regard to the denial of attorney fees, but none of that happened. So now what has happened is that because they filed a motion, appellant filed a motion requesting entry of an order that essentially just stated what this court had said, which the motion for modification of parenting time was denied. Appellant tried to use that to revive the attorney fee request a second time. Well, that's absolutely factually and legally incorrect, because the time for filing an appeal from that order from March 1st, 2024 had long since, or excuse me, March 14th, 2024 had long since passed. So I just want to make sure that's clear in this record, because the first order, March 1st, 2024 did not address the issue of attorney fees, but on reconsideration on March 14th, 2024, the trial court did deny attorney fees, and there was no appeal filed from that. So it's absolutely improper for the appellant to now go back and get a second bite of the apple. There's no legal basis to do so. Perhaps, yes, there's a basis to ask for appellate attorney fees. However, that request was also legally insufficient, because it's black letter law that anyone who requests an award of attorney fees must provide evidence that demonstrates that party does not have the ability to pay. A mere pronouncement that my client only makes $30,000 without attaching any pay stubs, without attaching any tax returns, without attaching any bank statements that demonstrate that their assets had been depleted such that they could not afford the litigation, that fails on its face. Nobody can be entitled to an evidentiary hearing when they don't make the proper offer of proof. And in fact, that's what happened here. There was no offer of proof that sufficiently demonstrated that appellant did not have the ability to earn her fees. In his answer, appellee answered that she didn't disclose that she received $1,200 of spousal support. She didn't disclose that she was her living expenses had been reduced because of her boyfriend. And again, most importantly, there was no evidence attached to the motion. So I would ask that this court affirm the trial court's decision denying attorney fees. And do you have any questions for me?
Any questions for Ms. Haas? We don't have any at this time. I'll ask my colleagues again. Any questions for Ms. Schmidt? No. Okay. Thank you very much.
Thank you. Nice to see
I
everybody.
appreciate your appearance here today, both of you, and the case is submitted. Thank you very much.
Thank you, Your Honor.
Okay, that brings us to item number 10. Docket number 374831, Terrence Kimbrough versus Hercules Drawn Steel Corporation. And Mr. Kimbrough, I take it you're endorsed for oral argument. You are the appellant representing yourself. And so you do have opposing counsel. So you have more than adequate time, I think, to address the court. And so I'll let you give us your appearance if you just state your name, and you can then proceed with your argument.
Thank you. Good morning, Chief Judge, and may it please the court. My name is Terrence Kimbrough, and I am plaintiff appellant appearing on my own behalf. The standard of review is abuse of discretion. I respectfully request that this court reverse this Circuit Court's February 27th, 2025 order setting aside the defaults and default judgment, and reverse the orders denying my motions for summary disposition and compel discovery, motion to compel discovery. The appellant relies on MCR 2.105H under Michigan court rules, specifically MCR 2.105H, authorized business leaders like a resident agent, officer, director, or person in charge can accept legal documents on behalf of the company or its employees. The appellant further submits that David Gunsberg was aware that the defendants had been served because he is a licensed attorney and he had served as a human resource president for the company for more than 40 years. Attorney David Gunsberg filed an answer on October 23rd, 2024, together with affirmative defenses and a notarized affidavit. Mr. Gunsberg answered on his own behalf, while the other defendants refused to file their own answers or otherwise respond to the complaint within the time required by the Michigan court rules. The record also shows that a professional process server, David Crensher of Bad News Barriers, completed service on October 7th, 2024. Mr. Crensher later confirmed during the proceedings that service was completed and reflected in the proofs of service. Because the defendants were properly served and the remaining defendants failed to timely respond, the clerk properly entered the defaults on November 4th, and it was a clerical mistake, so they entered the other defaults on November 21st, 2024. Under MCR 2.603 D1, a party seeking to set aside a default must establish good both cause and mysterious defense, and the appellees failed to establish either requirement. The appellees were therefore required to establish both good cause and a mysterious defense under MCR 2.603 D1 to have those defaults set aside. Setting aside those defaults prejudiced the appellant by reopening the case after proper service and the defendant's failure to timely respond. The appellant respectfully submits that the appellees failed to satisfy that burden, and the trial court abused its discretion. For those reasons, I respectfully request that this court reverse the order setting aside the defaults and reinstate the defaults and default judgment. Appellant respectfully preserves all issues for further appellant review, including under MCR 2.603 D1 and the trials court abuse of discretion and set aside the defaults.
Thank you. Any questions for Mr. Kimbrough? Okay, nicely done, sir. And you'll have time for rebuttal argument if you wish to exercise that.
Good afternoon, Your Honors. I'm Courtney Lavender on behalf of defendants appellees. So this is an appeal of the trial court's grant of defendants' motion to set aside default judgments and grant of defendants' motion for summary disposition and denial of plaintiff's motion to compel discovery. Plaintiff largely relied on arguments that were already contained in his brief, so I don't have much to add. That wasn't already in my brief as well. I did just want to make one correction of the record. In Exhibit 8 to plaintiff's appendix, he did attach Mr. Krucher, the proposed process server's affidavit, which actually does support that he did not properly serve defendants. He did indicate that he attempted to serve all 8 summons and complaints on defendant Gunsberg on October 7th, 2024, but that defendant Gunsberg would not sign any affirmation of that and explicitly told him that he would not do that. So that supports defendant's position. But other than that, I believe the matters are relatively straightforward, so I'm going to rely on my brief for the remainder unless your honors have any questions for me.
Any questions from Ms. Lavender? No, thank you. Mr. Kimbrough, would you like to say anything in response to that? Okay.
Judge Elder reasons for granting their motion to set aside the defaults was due to service not being complete, in which it was. That mistake is so obvious. On the Pilly David Gunsberg complaint, each defendant names are stated in the name box in which he received. The defendants also have a history of purposely going into default, thinking that the appellant wouldn't catch it. The defense strategy their strategy is to never answer to any complaint and then file a motion for summary disposition in lieu of an answer to avoid answering to their complaint instead of answering by omitting or denying.
Very good. Thank you. We appreciate your arguments and thank you for appearing in court today. And the case is submitted. We'll try to get a decision to you, Mr. Kimbrough and Ms. Lavender, in short order. Thank you. All right, that brings us to item 11, right? Item 11. Docket number 377114, In Re Asher Miners. And petitioner appellee is the only party endorsed in this one. Would that be yourself? Okay, we'll take your appearance and any argument you wish to.
Thank you very much. Good afternoon, Chief Judge Godola and Judge Cameron and Judge Monstra. Jonathan Misick on behalf of the people representing Department of
Health and Human Services.
Yes, Judge. Forgive my stutter. I'm sorry.
That's okay.
But as I have no opponent, I rely on my brief and yield for any questions.
Any questions? I don't think so. Did you say you have a stutter? I'm sorry.
Yes, Judge.
Okay, thank you for letting me know. I didn't know.
No, it's okay.
Yeah, I apologize.
No apology necessary.
Yeah, okay.
But I do want to make one correction on my brief. I noticed in preparation for my oral argument today that it was incorrectly captioned as an application for leave. I apologize for that massive typo on my part.
That's okay.
Won't happen again.
No problem. Thank you very much.
Thank you.
We appreciate your appearance today and the case is submitted. That brings us then to item 12, docket number 378090, In Re Carroll Miners. Attorney Dean is endorsed, but I don't see her in the courtroom, not checked in. So that case will be submitted on the briefs. And we have three more items. No one's endorsed in any of them. Item 13, docket number 378517, In Re Richardson Miners will be submitted on the briefs. Item number 14, docket number 373268, David Perry versus Ernesto Lasada will be submitted on the briefs. Are you Mr. Perry? Okay, you're not endorsed for oral argument today. So, normally I'd have you come up and make an appearance and present an argument, but you didn't preserve oral argument. So we won't be able to hear from you today, but we'll try to get a decision to you as quickly as we possibly can. So appreciate you coming. If I could give you one piece of advice for future reference, hopefully you never have to be in a courtroom for anything ever again, because I mean, we might be the only ones who look forward to being in a courtroom, the three of us.
One day you can retire.
I hope one day too, but I love Run DMC as much as the next person, but I don't consider that appropriate attire for court. So.
Where I lost my house.
Oh, okay. Understood. All right. I appreciate that. So thank you. Okay. Very good. Thank you for coming today. And we'll try to get a decision to you very quickly. Thank you. Item 15 is the last item for today. Docket number 375313, Amna Mahmood versus Irfan Mahmood will be submitted on the briefs. And with that, we will be in recess until 10 o'clock tomorrow morning. All right.